Good morning. Good morning. We are going to begin this public hearing of the Judiciary Committee for today, Wednesday, March 4th. Any comments from my co-chair? Seeing none, let's get right down to business. We have a short list today. See if we can get through it. We will begin with number 1, Daniel Buchanan.
Good morning, Chairman, ranking members, and distinguished members of the committee. Thank you for allowing me to testify today in strong support of raising the notary fee from $5 to $10. I want to especially thank State Senator Kissel for sponsoring this bill and State Representative Blumenthal for his leadership and support. Your work on this issue means a great deal to small businesses and thousands of Connecticut families who rely on notary services every day. As I outlined in my written testimony, the key reason we need this increase, after decades without adjustment, the current $5 fee is no longer sufficient. It simply doesn't cover the real costs we bear. My name is Dan Buchanan. I own multiple UPS stores here in Connecticut. Like many of my fellow franchise owners, we proudly offer notary services as a convenience to our customers. Currently, there are 44 UPS stores across our state that make notary service quick, easy to access. Many of our customers stop in on lunch breaks, after work, or on the weekends when other offices are closed. If for economic reasons we are forced to stop offering notarizations, tens of thousands of Connecticut citizens will suddenly find it much harder to get documents signed, real estate closings completed, power of attorneys executed, and other important legal papers handled. We don't want to reach this point. That is why we need your help today. Passing the bill will allow us to continue to provide this public service to ensure convenient access for every citizen, family, and small business owner in our state. Thank you again, Senator Kissel, Representative Blumenthal, and the entire committee for your time and for your commitment to keeping Connecticut working for all of us. Thank you.
Thank you. Appreciate that testimony. Are there any comments or questions from members of the committee? Comments or questions from members of the committee? Seeing none, I want to thank you for joining us this morning. Beth Hamilton.
Good morning, Senator Winfield, Representative Stafstrom, Senator Flexer, Senator Gadkar-Wilcox, Representative Fazzino, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for the opportunity to testify today. My name is Beth Hamilton, and I am the Executive Director of the Connecticut Alliance to End Sexual Violence. We are a survivor-centered and survivor-led coalition, and our mission is to prevent and eliminate sexual violence in our state through education, legislation, advocacy, trauma-informed care, and a statewide network of support for victims and survivors. The Alliance strongly supports SB 89 and Act updating prison rape elimination standards. SB 89 codifies the Federal Prison Rape Elimination Act, or PREA, into state law, requiring all state and local agencies that incarcerate or detain adults or juveniles to comply with PREA standards. PREA is a federal civil rights law enacted in 2003 to prevent, detect, and respond to sexual abuse and harassment in confinement settings. It establishes national standards focused on prevention, accountability, and survivor safety, and access to support for incarcerated survivors. While PREA applies nationwide, it is not self-executing and relies heavily on state-level adoption, enforcement, and oversight to be effective. Without codification, compliance can be uneven and subject to shifting federal priorities, as evidenced by the recent removal of key standards related to risk reduction, screening, housing placement, searches, and other safety measures based on gender identity, protections that had been in place since 2012 to address the heightened risk of sexual abuse faced by incarcerated LGBTQ people. Research consistently shows that sexual violence in custody is both common and has serious, long-lasting consequences. Survivors frequently experience post-traumatic stress disorder, anxiety, depression, suicidal ideation, and these harms are often compounded by confinement, past trauma, and existing mental health conditions. A December 2025 report from Disability Rights Connecticut documented high rates of sexual abuse at York Correctional Institution and the many barriers survivors face in reporting and seeking services. Their findings echo what our advocates hear directly from incarcerated survivors who contact our hotline or seek support. Incarcerated survivors are wholly dependent on correctional institutions for their safety, care, and ability to address harm and report harm, making them uniquely vulnerable to abuse, retaliation, and silence. When reporting systems fail, survivors have nowhere else to turn. At the state level, PREA implementation has been inconsistent. Survivors lack timely access to advocacy and services. It is often unclear whether investigations are conducted or what their outcomes are. This legislation would make protections enforceable, create transparency through reporting and independent oversight, and mandate access to services for those survivors. SB 89 requires annual certification of compliance, mandates public reporting to legislature on staff training, the number and types of sexual assault reports, investigations, and their outcomes, and strengthens independent oversight by requiring complaints to be transmitted and reviewed by the Office of the Correctional Ombuds. It ensures that federal PREA standards are enforceable, transparent, and subject to meaningful state oversight, including survivors' timely access to confidential sexual assault advocates, medical care, forensic exams, and mental health support. Codifying PREA transforms guidance into accountability in our state and affirms that sexual abuse in custody is not inevitable nor acceptable. We urge you to support SB 89, and thank you for standing with survivors in your communities.
Thank you, and thank you for coming back. Comment or question from members of the committee? I do have a question. Some of us were working on a very similar bill when this bill came to us from the governor, so we have a public hearing. I think one of the bigger questions between the work that was being done and this bill is whether to reference PREA or to incorporate it fully. Do you have a comment on that as it relates to your work?
I think that the challenge being that PREA as it stands, right, we had a 2011 legislation that said that we had to follow the PREA Commission, which was a point-in-time commission that no longer exists. I don't think that there is necessarily any harm with codifying it as it stands and not necessarily saying you must follow PREA. I know that the intention of this bill and putting it for January 1st of 2024 was because of the changes at the federal, the rollbacks at the federal level. Mm-hmm. But I don't think that it necessarily has to follow federal PREA. I think it has to follow what is in there. I don't think it necessarily has to codify exactly in that way. But I do think that most of what you see there are challenges that folks are having right now, being enforceable, being followed through on, and then holding folks accountable when that's not happening.
Okay. Further comment, question from members of the committee, further comment or question? Seeing none, thank you very much for joining us. Senator Austin, you are up.
So good morning, everybody. I'm Kathy Austin. I'm a state senator. I'm a state senator, also worked in the Department of Correction for 21 years out of my work life. And I also worked at a federal correctional facility in Rhode Island. So I have some experience relative to PREA, the prison rape elimination standards that you are all discussing. I will be submitting written testimony, but I would like to say there's a couple of things that I would like to see this piece of legislation incorporate. I think it has to be incorporated in the statute because federal law changes. Federal law changes all the time, no matter who the administration is. So this is the same thing that I did when I worked with people on the Indian Child Welfare Act, where we did not just reference the federal law, but outlined the federal law so that we were standing with a certain standard and not falling backwards should there be a change in federal policy. I also think that we should include in this reporting on incidents of sexual assault or sexual harassment for the staff that work within the confines of the prison system. I think that that's an important component here. It should be incarcerated person on incarcerated person, staff on incarcerated person on staff, and staff on staff. So that we have a real record of sexual harassment and sexual assault. I also worked as a member of the Department of Corrections with a number of women. Some 70 women came up here in the General Assembly, testified on sexual harassment. There was a very large lawsuit that happened that ultimately came to a standard that outlined different things that we would handle within the confines of the Department of Corrections. We had outside groups that sat and reviewed cases and on a monthly basis, went to a quarterly basis, and have since been disbanded. And inside groups that worked with staff from different facilities that looked at these cases. They were mostly dealing with staff issues. The outside group dealt with the incarcerated population issues also. I think it's important for us to reconstitute all of those groups so that we have a review policy within the confines. And I don't want to go beyond my 3 minutes because this is an issue that I consider really important, and I appreciate you taking this up.
Thank you. Comment or question from members of the committee? Comment or question? There are none, but I want to thank you for your continuous work on prison rape issues, and appreciate your commentary on the question I asked the previous speaker. I think it's important to this discussion that we're having here today. I think it may be one of the more crucial questions in the future, looking back. So I want to thank you for your efforts here.
Thank you. I appreciate it.
Yeah.
Appreciate your work. Have a nice day.
You too. Attorney Taubes, Alexander Taubes. Alexander Taubes. Alex Brown. Good morning.
Good morning. Okay. Good morning. My name is Alex Brown. I am here today not only as an MSW student at UConn and a policy advocate, but as someone whose experience of sexual abuse while incarcerated is documented in the investigation conducted by Disability Rights Connecticut, Incident 6, Jane Doe number 4. When someone is incarcerated, the state controls every aspect of their daily life, where they sleep, where they shower, and who has authority over them. The Federal Prison Rape Elimination Act was passed more than 20 years ago to prevent sexual abuse in detention facilities. Yet, investigations at York Correctional Institution, the only women's prison in Connecticut, documented serious failures, including sexual abuse by correctional officers, failures to conduct incident reviews after assaults, gaps in surveillance, and failures to provide appropriate mental health care to survivors. Across the country, national surveys conducted by the Bureau of Justice Statistics estimate that tens of thousands of incarcerated people experience sexual victimization in prisons and jails each year. And research consistently shows that many incidents go unreported because survivors fear retaliation or believe nothing will change. The Disability Rights Connecticut investigation into York found systemic failures in how allegations were handled, and multiple correctional staff members were later convicted of sexual misconduct or sexual assault connected to abuse at the facility. Unfortunately, what happened at York is not unique. Investigations across the country have shown that sexual abuse in custody often happens in systems where oversight exists on paper, but real accountability is difficult to access. Right now, people who are abused in custody often have to ask permission from the state to go through the claims commissioner before they can even bring their case to court. For many people, that process becomes a barrier to ever seeking justice. SB 89 takes some important steps towards improving oversight, but oversight alone will not solve the problem. The bill should also address the structural conditions that allow abuse to occur. That includes using person-first language such as incarcerated person, rather than dehumanizing terms like inmate in the bill language. This can shape how people in custody are viewed and treated. It also means addressing cross-gender supervision and stripping practices in intimate spaces such as housing units, showers, and bathrooms. When someone is incarcerated, they cannot choose who supervises them or when they will be forced into a state of undress. That power imbalance creates real risks of abuse and re-traumatization. Meaningful reform must acknowledge past harm. Survivors whose cases were ignored or mishandled should not simply be left out because the abuse happened before this bill takes effect. When the state incarcerates someone, it assumes complete responsibility for their safety. With that level of power must come real accountability. I urge the committee to strengthen SB 89 so that it truly reflects the dignity, safety, and humanity of the people whose lives depend on these protections. People deserve more than oversight on paper. We deserve laws that actually protect people in custody. Thank you for allowing me to testify.
Thank you, and thank you for coming. Comment, question from members of the committee. Comment, question. We have your written testimony, I assume.
I'll submit it.
Yeah, thank you.
Thank you.
It's important. Some of your recommendations, I think, are particularly important, and I want to thank you for coming. I know your work, but I want to thank you for coming to share. It's important that we hear from people with real experience.
Thank you.
Thank you.
Thank you.
Matthew Mitchell. I almost said Matt. I think that would have been okay.
Good morning, distinguished chairs, ranking members, and member of the Judiciary Committee. My name is Matt Mitchell. I serve as Assistant Ombuds and Special Investigator with the Office of the Correction Ombuds. I am appearing today to deliver testimony on behalf of Correction Ombuds Devon Ward in support of Governor's Bill 89, an act updating prison rape elimination standards. Sexual violence in custody is not an unfortunate byproduct of incarceration. It represents a constitutional breakdown. Individuals in state custody are wholly dependent on the government for their safety. When sexual abuse occurs inside a correctional facility, it's not simple misconduct. It is a failure of the state's most fundamental obligation to protect those it has confined. Governor's Bill 89 takes an important step by codifying PREA standards in the Connecticut statute. PREA is a federal civil rights framework designed to prevent, detect, and respond to sexual abuse in confinement settings, but it relies heavily on state enforcement to be effective. Recently, the federal infrastructure that historically supported PREA implementation has weakened. In April 2025, the United States Department of Justice terminated federal funding for the National PREA Resource Center, which has been responsible for training PREA auditors and providing technical assistance to correctional agencies across the country. This occurred alongside the termination of hundreds of Department of Justice grants totaling roughly $800 million nationwide. When federal enforcement weakens, state oversight must strengthen. By codifying PREA standards into state law, this legislation helps ensure that protections against sexual abuse in custody remain durable, regardless of changes at the federal level. However, codification alone is not accountability. Under current law, survivors of sexual abuse in custody must navigate the claims commissioner process before accessing court, and they must exhaust administrative remedies under the Federal Prison Litigation Reform Act. These layered procedures can significantly delay access to justice. In a custodial setting where the state exercises complete control over a person's environment, access to judicial remedies should not depend on administrative gatekeeping. Connecticut has already recognized in the context of medical misconduct in correctional facilities that individuals may proceed directly to suit. A similar principle should apply here. Where there is a verified PREA complaint, a substantiated Department of Correction Security Division investigation, or a police report in arrests arising from sexual misconduct in custody, survivors should be able to proceed directly in Superior Court through a narrowly tailored statutory cause of action. Recent events underscore why enforceable protections matter. Public testimony before this committee had described the case of LaShonda Gregory, a woman who incarcerated at York Correctional Institution, who has alleged that she was statutorily raped by multiple correctional officers and later transferred out of state to a facility in Delaware in what has been described as a retaliatory transfer. Allegations of the nature highlight the structural vulnerability of individuals in custody and the importance of clear protection for those who report abuse. At the request of members of the legislature, the Office of the Correction Ombuds is currently conducting an independent investigation into matters related to Ms. Gregory. I am serving as lead investigator on that review. Because the investigation is ongoing, we cannot comment on findings today, but these circumstances illustrate why strong statutory standards, independent oversight, and enforceable remedies are essential. Governor's Bill 89 is important to step forward with targeted amendments and strengthen enforcement and ensure survivors have meaningful access to justice. Connecticut can ensure that zero tolerance is not simply declared but guaranteed. Thank you for your consideration.
Thank you. Comment or question from members of the committee? Comment or question? I just want to thank the office for weighing in here, particularly as it relates to the ongoing case and how it highlights the importance of what's before us. I will ask you a question I will not ask you to answer right now, but have your office respond to. And that is a question that I've asked others. I know you're testifying on a bill that is laying here. I would ask the office if they would care to respond on my question about the way in which we're incorporating PREA and how important that is. And also, there's testimony such as Ms. Brown's about language in the bill and how that has impact. I would also ask your office if you would care to comment on that. So if you could take that back and get an answer for us on that, I would appreciate it.
Yes, sir, will do.
Thank you. Good to see you.
Thank you. Have a great day.
All right. Brian Caffarelli.
Good morning. I'm Brian Caffarelli, the Commissioner of Consumer Protection. Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and the distinguished members of the Judiciary Committee. It truly is an honor to be here before you. And thank you for the opportunity to testify regarding Senate Bill 296. And essentially the bill does two things. It has an amendment or proposed amendment to the CUPPA and has a change in a proposed change in our gaming statutes. With regard to CUPPA, currently the Connecticut Unfair Trade Practices Act limits orders of restitution to $10,000. And we recommend increasing the cap, which has not been increased in over 10 years. The last time it was increased in 2015, it went from $5,000 to $10,000. And we've received an increased number of complaints involving fraud and damages that involve more than $10,000. For example, home improvements and motor vehicles. We also receive complaints where the total amount involved is more than $10,000 due to the large number of consumers affected by it. So allowing the agency to prosecute these cases provides a consumer benefit, especially for low-income complainants in terms of cost and expediency. And I think it's helpful to give you some examples as to why we believe this should be increased in cases that we've attempted to handle. Last year, we had a CUPPA case where a consumer paid approximately $23,000 for church renovations to their windows that were never completed. And under current law, restitution is capped at $9,999. And that's the most that we could award, which meant we had to advise the complainant that they then had to seek redress with the courts for the remaining $13,001 through a civil lawsuit, which is costly and time-consuming and consume much of any recovery that a small business, or in this case, a church, would get. So raising the cap to $25,000 would have allowed this consumer to be made whole without going to court and would provide similar relief for many others who lack the resources to sue. This change addresses the critical gap and ensures CUPPA remains effective remedy rather than a partial solution. So some other examples of losses that have exceeded $10,000 are used car purchases, often ranging from $15,000 to $20,000, which have involved hidden damage, falsified histories, material representation, for example, where a dealer advertises the car as certified pre-owned, accident-free, and in excellent condition, but the consumer later finds out that it was in fact in an accident. It covers major HVAC installations, which typically range from $12,000 to $18,000, and I see my time has expired.
Just real quick, if you could just maybe summarize the gaming statute piece as well.
Sure. It amends 53A127D to include offering or accepting undue advantage with the intention of improperly altering the outcome of a sports wager. So what this does is this is consistent with the expansion of sports gaming in Connecticut. So the statute now does not cover the online portion of essentially rigging sports games.
Senator Kissel?
Thank you very much. Thank you very much, Chairman Staffstrom. Commissioner Caffarelli, great to see you. I was brought to my attention that you wanted to chat a little earlier. I apologize to everyone. I was at a breakfast in Enfield at my community college, which is now part of the state system, and it was traffic was heavy getting in. Regarding the unfair trade practices, back many years ago when I was in private practice, I brought some civil actions utilizing the Connecticut Unfair Trade Practices Act. I understand the value of increasing the amount that would be available to the Department of Consumer Protection, especially in light of the example that you just provided regarding the stained glass windows. I'm assuming they were stained glass, but the church windows whose value exceeded that you were allowed to get back for the consumer. How would this change, if at all, affect folks that are bringing private actions under the Unfair Trade Practices Act? In other words, does this change that you're seeking only apply to the Department of Consumer Protection, or would it have some sort of spillover effect on private litigators as well?
I will have to follow up with you, but my understanding is that the awards that we are allowed to it's what the commissioner can order of restitution with regard to a CUPPA hearing that we administratively prosecute. But I can confirm that.
And the only reason I ask that is, like, quite often we refer to the Unfair Trade Practices Act as allowing individuals to act as private attorneys general. And so I just want to make sure that the interreaction between civil litigants and the State Department is somewhat seamless, and one doesn't sort of like bump into the other on causing impractical ramifications. So just if you could follow up with that information, that
Sure.
would be terrific. And the other thing is, I know that there's, at least anecdotally, I don't have the statistical data, but the online gambling, especially amongst young people at colleges and things like that, one of the things that was heavily debated when we went down this road was, if it's like so much easy access, if it's just someone on their cell phone, all of a sudden they could lose a lot of money really fast. And they may not even have legal responsibility to do that, but we'll set all of that aside. When you testified in response to Chairman Staffstrom, it sounded like you were talking about rigging games and things like that. I'm just wondering, I haven't heard anything about that happening in Connecticut. Is that a common problem that we have?
No, it's not. It is, so it's cheating, which is the statute, and it is happening more as the market expands in other areas of the country. And so it would only apply, obviously, to activities in Connecticut, but it is something that we feel needs to be updated and to keep up with the times. So no, we don't have a whole host of rigging sports betting in Connecticut. There have been pretty visible examples of that in professional sports leagues across the country, but it has happened at the college level and other levels in other states. So we don't have any complaints currently with regard to Connecticut, but it is something that it's a trend. We're not trying to solve a problem that doesn't exist. It's just more of a when it will happen here.
So you're betting, no joke intended, no pun intended, that it's an inevitability. Just one last follow-up, Mr. Chair. If we go along with this proposal regarding gambling and giving you more authority, how would that put us as far as comparisons with other states?
I think I don't have a state-by-state analysis of where we are. I know that this would just expand what qualifies as cheating under the current statute. The penalties would not change.
Okay. Thank you. That clarification is important. And to the extent, one of the things that is always helpful, at least to me, is when people come and they say, this has already happened in New York, or the New England states are moving in this direction, or we're an outlier when it comes to this particular provision. So to the extent you can sort of place us on the map as far as where we stand regarding all of this, then it'll help me help move the bill if it looks like we're just way behind.
Sure.
But I actually find it heartening to know that we're not in the lead when it comes to gambling, rigging, and things like that. But we want to give you the tools to make sure that nobody goes down that path, and if they do, that there's severe consequences for that deleterious behavior.
Thank you, Senator.
Thank you very much, Mr. Chair. And by the way, thank you on the terrific job you're doing as Commissioner.
Thank you,
Mr. Chair.
Senator.
Further questions or comments? I guess maybe more of a comment than a question, Commissioner, but it seems like what you're trying to do on this CUTPA thing is cut down on litigation in the state of Connecticut. Is that the case?
Yeah, I think that that's a fair statement that, for two reasons. One, that in the church example that I gave, the respondent would have to answer to the administrative action and then also a potential civil suit to get the $13,000. And in other cases, the department does investigate claims and will only bring claims that have merit, unlike the low bar that is required to file a civil action.
If I'm not mistaken, at one point you were a staffer on this committee, were you not?
Yes, Mr. Chairman.
Okay. So you would know how we feel about cutting down on litigation in the state of Connecticut. Representative Howard has a question for you.
Thank you, Mr. Chairman, and good morning, Commissioner. Always a pleasure to see you. Sorry I'm not there. I'll be up shortly. We have 300 and some people in education today, so I'm taking the later shift. But regarding the sports wagering question, just for consideration, that statute, as it currently exists, all activities regarding the current language would have occurred in Connecticut. My only question is, what we're doing now is we're creating a crime, and perhaps the game is taking place in another state. And I'm wondering if there's a jurisdictional question that we can answer ahead of time. And I would refer you to 53A 183 of the general statute as an example, which is harassing phone calls, and it specifically says it can be enforced whether the call was received or made in Connecticut. And I just don't know if we might be interested in clarifying that language a little bit, that if the bet had to have taken place had to be placed here in Connecticut, because as you well know, that's geolocated, or if the event had to take place in Connecticut, or if we maybe want to clean that up so we don't have a prosecutorial question in the future.
Fair point, and we will, the intent is to apply to activity within Connecticut, but I hear you with regard to the betting on activities outside of Connecticut. So
Right, thanks. I'm just bringing it up as an observation that, perhaps if the intent was bets that are placed in Connecticut, or gaming, or the actual sporting event, the basketball game or whatever it was taking place in Connecticut, what the intent was, maybe a bit of clarifying language there so it doesn't become sort of a, prosecutorial loophole in the future if this were to occur. Thank you. And thank you, Mr. Chairman.
Thank you.
Further questions or comments? If not, Commissioner Katsania.
Thank you for your time.
Next up will be Kate Hickey.
Hi, good morning, members of the Judiciary Committee. My name is Kate Hickey. I'm from Old Lyme and an MSW student at the UConn School of Social Work. I'm here today to testify in support of SB 89, Prison Rape Elimination Act bill. This bill will require any state agency that is charged with incarcerating people to follow the standards that are outlined in the federal law. It would also require all sexual assault complaints to be sent to the state's correction ombuds for review. The Department of Correction would then have to report each year the number of sexual assault complaints they have received, the investigations the department has undertaken, and any training the department has provided employees regarding the Prison Rape Elimination Act. Sexual abuse in custody is a systemic and well-documented issue that has long been ignored. A recently published 4-year investigation found that the Connecticut Department of Correction failed to address multiple sexual assaults at York Correctional Institution. The investigation shows that survivors of sexual assault tried to make PREA reports, but the Department of Correction did not take them seriously. These women were left without any help, but were left only with the harmful memory that will remain with them for the rest of their lives. Without putting these PREA standards into state law, the lack of oversight and accountability of sexual assault in our prisons will continue. This is why I'm asking you to support and pass this bill that will help to prevent sexual abuse in prisons, jails, and other correctional settings. Thank you for your time and consideration.
Thank you. Well done. Questions or comments from the committee? If not, thanks for being with us. Cindy Prizio. Cindy Prizio with us? No? Okay. Eva Lace Correa. How about Denise Mateo? All right. Chris Drake.
Good morning, Representative Stastrom and Senator Kissel and members of the Judiciary Committee. My name is Christopher Drake. I'm the Director of Business Services for the Office of the Secretary of the State. Thank you for the opportunity to testify on Senate Bills 294 and 262. These bills were directly shaped by our office, and thank you for raising it on our behalf. The Business Services Division operates the State Business Registry. We also operate the UCC Lien Registry. We commission notary publics, and we issue document apostillees. These services are used by municipalities and banks and courts and most importantly, other businesses every day. The provisions that we have recommended in Senate Bill 294 come from some real-world experience from over a year of operating the statewide centralized trade name registry in cooperation with the Connecticut town clerks. So these changes that we're suggesting reflect conversations that we've been having with those town clerks over the last year, and the goal there is to streamline that process and make the job of town clerks easier. The fraudulent filing fix that we are suggesting is a common sense approach to use a less aggressive means to address fraudulent filings when that is appropriate. We have some language in 294 that addresses deceptive business solicitations. We receive dozens of complaints each year from small businesses that are misled by mailings that look like official government documents. So we're trying to make the law more robust there and put in place some consequences. And then finally, we are proposing some changes to the notary language. Most importantly for us, to make it more explicit that the Secretary has regulation authority to write policies and procedures outlining the steps she will take when we receive complaints of notary misconduct. We're also suggesting raising the fee for notary publics to charge from $5 to $10. It's been about 25 years since that fee was raised. Thank you for the opportunity to address the committee, and I will be happy to answer any questions you have.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Attorney Drake, great to see you again. Can you just, I probably should be able to glean it from the language of the proposal, but you had said that part of the goal here is to make life a little easier for town clerks throughout Connecticut. And I'm just wondering if you could give like a real life example of what's happening now that will be better for town clerks down the road should this legislation pass.
Sure. So prior to a bill that was put forward by our office in 2024, trade names were all filed at the local level. What that led to is that there were businesses on our registry that had been filing trade names in local town clerks, but that data didn't speak to one another, so you wouldn't necessarily know that that was the case. So the goal behind centralizing the trade name registry was to marry that data together so that we know which LLCs are operating under which trade names and in which towns. So we have, for the last year, have over 100 towns that are using this system. The changes that we're asking for in this bill are mostly just to reflect kind of ambiguities in the law that got passed 2 years ago. So things like what happens when ownership changes, what's the process. So what we're suggesting in this bill is we'd be instructing the town clerks to file a new trade name and cancel the previous trade name to reflect that the new owner is the operative holder of the trade name and the previous owner is no longer. So that's kind of a simple example of something that we stumbled on over the last year where the law really wasn't that clear on what to do in that situation.
Great.
Thank you.
It's always nice to know that we did something good, and now we're just trying to dot the i's and cross the t's. And did you say at your initial presentation that the Town Clerks Association were supportive of this proposal as well?
They were. We spoke to them a couple weeks ago. We went over the bill. The only concerns they raised were on the provisions around the prohibited terms, and so there's a provision in that bill that basically says that if you can't use in a trade name terms like LLC or corp or incorporation because statutes already reserve those terms for truly incorporated entities. Their only concerns were around operationally, how to operationalize that. And so, we talked through it with them about what changes we're planning to make with the system to make it obvious for them to block those names coming in the system. And then we also talked about fail-safes, what happens if they let one through, what we could do on the back end to fix one. So I wouldn't say they had any objections to that. I would say that they were just, because it's an unknown thing that they haven't done before, that they just wanted some assurance that we would be there to support them.
And you're there to support
We're there to support them.
Okay, very good. Thank you, Mr. Chair.
Further questions or comments from the committee? Representative Jacobson.
Thank you, Mr. Chairman. Good morning, Mr. Drake. Is my understanding correct that if a member of the public wanted to look up a trade name certificate, despite a centralized filing, there's no online platform for it? They have to inquire with the specific town clerks for the municipality upon which the trade name has filed a certificate?
Right now, we're in a hybrid situation. So trade names filed prior to January 1st, 2025, you would have to go to the town. The whole goal of the centralized trade name registry is to make it searchable online completely. Unfortunately, we had to address the fact that many of these trade names have been filed for decades, and so we had to put a fairly long expiration period on them. So for right now, if the trade name was filed before 2025, you have to go to the town. If it was filed after 2025, it should be searchable on business.ct.gov.
And are there efforts being undertaken to incorporate those trade names filed prior to 2025 into some sort of modern, electronically accessible mode of search?
The way the current law operates is all those trade names will expire 5 years from the date that the bill went into effect. So it was January 1st, 2025. So that would be December 31st, 2029. So at that time, none of those trade names will be relevant anymore. We offered to towns to file for them all trade names going back to 2025. So they sent them to us, and then our staff inputted them. I don't think that there's enough resources for us to take that on going backwards in time. So we're hoping that eventually we close the gap, and that as of 2029, we can say finally, this system reflects all trade names in Connecticut.
Okay, thank you for that. And just a comment, Mr. Chairman, I applaud the Secretary's office in modernizing the manner in which, let's say in my private practice, I would look up a business organization on the Secretary of State filing. But I've actually recently discovered what I would characterize as a more archaic approach of having to go town to town and see if something was or was not filed. So I'm glad to see that there's processes in place to bring this up to the 21st century. Thank you, Mr. Chairman.
Further questions or comments from the committee? If not, thanks for being with us.
Thank you.
Anybody who was signed up that we missed that has joined us, Madam Administrator? If not, then we will declare this public hearing closed for today. Might be the shortest Judiciary Committee public hearing in recent memory. with that, we will be back on Monday and Wednesday next week for what I expect will be longer public